Well, hello, everybody, and welcome to a new and improved version of Morning Latte with the Buechlers. I'm William Buechler with the National Educators Law Institute and Buechler & Associates PC. And with me is my beautiful wife and partner, Cynthia Buechler, also of the National Educators Law Institute and Buechler & Associates. And we're here today, we're going to discuss a new Fifth Circuit case, from a case out of the U.S. Court of Appeals for the Fifth Circuit dealing with special education. The case is Boone versus Rankin County Schools out of the great state of Mississippi. And just to clarify how all this works, the U.S. Court of Appeals for the Fifth Circuit oversees Texas, Louisiana, and Mississippi. So when the Fifth Circuit speaks on a case, we listen, because all school districts, all public school districts in those three states are bound by their decision. So Cynthia is going to give us some of the background facts first, and then we'll work through the case, and then what kind of lessons can we learn from this case as we move forward in the next school year. So Cynthia, first of all, let's talk about the facts of this case.
Yeah, it's an interesting facts that we have in this case. Again, it's Boone versus Rankin ISD. And it just came out. And the issue with this case is that the student was a student that had some autism, and some significant behaviors. And those behaviors include things such as aggression, also obsessive compulsive behaviors, as well as elopement. And for those who don't know what elopement means, it means running away. And so
not running away to get married, it's a different type of running away in the school
that's
context.
Exactly right. Yes, this is where you're afraid they're going to run on a busy street or on a highway. So he wasn't staying in the school. And so they had to deal with those issues, and they had him since kindergarten, but at some point they decided to place him in a private school for autism. So the school, through their IEP meeting and agreement with the parent, placed him in this private school with students for autism. And while he was there, he continued to have behaviors, including the aggression and the elopement, as well as the obsessive compulsive behaviors. It was also during the COVID year, as we all remember COVID, he, during one of those incidences, he took a mask and wiped his back end with it. Another student's mask, not his mask.
Yeah, that's charming.
Yes, and 2 weeks later, all of a sudden, the school's having an IEP meeting trying to bring him back. And in that meeting, the parents said, why are you bringing him back? And they're like, oh, he's doing great. It's like, how can you say he's doing great when we're still having these behaviors? And so the parent disagreed with bringing him back. And apparently the principal said, well, we want to bring him back right away. We're going to bring him back to middle school. At this point, I believe he's 14. And mother says, why don't we just look at other options? So they came back in 2 weeks, and the parent was wanting them to look at least going to the high school versus middle school, so there wouldn't be a transition going from those two different schools. We just have one transition. She also said they had reached an agreement. They had that before he was transitioned back, they would look at schools that had, smaller settings where he could transition better from the mother's perspective. So school said, no, he needs to come back to his home campus, and it's going to start right away. So there you go.
So we have an impasse. So I'm assuming this is where litigation started.
Indeed.
Okay, so the parent files a due process hearing through the state. So what happens at the due process hearing?
So at the due process hearing, the hearing officer ruled that the IEP that had been developed on behalf of bringing him back was not appropriate and didn't provide FAPE because it didn't address one of his major issues, which was elopement. And they said, and the hearing officer said the school was aware he eloped, it wasn't a new behavior, and that should have been addressed because that was one of the reasons they even put him over at the private school, because the private school had locks and fence. So it was clear that the private school was something that elopement was meant to address. So they were aware of it, and it hadn't gone away, and he was coming back to the school. And so they said it was not an appropriate program based on that. He also said that there was not a collaborative effort because the parent would request these other things, and rather than considering that, he said this is his home school, be where he goes. And at one point, the principal said, well, I talked to the special ed director, and this is where he's going because this is his home campus. And so that added with the fact that they did not consider those other options, at least within the context of this decision, he ruled that it was not an appropriate program.
Okay, all right. So did the school district appeal, the parents appeal, or what? First of all, I guess what relief did the hearing officer grant?
He granted, what the hearing officer ordered is that the school conduct a reevaluation, that they develop an appropriate IEP, which included addressing the elopement, obviously, it had a safety plan in place. So those measures were put in place for the school, for the parent, based upon her filing that decision. What did not happen is the ordering of compensatory services, which was interesting because the facts, at least that were relayed within the decision, was that when he was 7 years old, he was performing at first grade level.
Mm-hmm.
He's now 14 and he's performing at kindergarten level, which is not a good
Seems like we're
set of
backtracking.
facts.
Yeah.
A really bad set of facts, because that's a 7 year
Sure.
time frame. And not only did he not make any gains, but it looks like he regressed. So those are very interesting that he didn't award in compensatory services. Now, of course, you're limited only to 2 years, but even with that 2 years, you could say what's happening. So the parent appealed because she didn't get compensatory services, and the force of school appealed because they found they didn't provide FAPE.
Okay, so as we know, when either party is dissatisfied with the decision of a hearing officer, you can appeal into federal district court. Both parties appealed on this one. Federal judge hears it. What does the federal judge say about all this?
Federal judge affirmed the hearing officer across the board.
Okay.
Now, the hearing officer, said, here's what we're going to do. You did not have an appropriate program. That stayed. The parent, of course, was seeking attorney's fees at this point because that's where you can get them in district court, and they were awarded. And then compensatory services, so that's what the parent had appealed, and they said, no, the hearing officer did not abuse their discretion in not awarding compensatory services.
Okay, interesting. So at this stage, now what do the parties do? Is everybody happy and they go home, or what happens?
Nobody's happy. It gets appealed up.
So now we go up, now we're at the Fifth Circuit. Now we go to the U.S.
Circuit's there.
Court of Appeals for the Fifth Circuit. Okay, so the Fifth Circuit, when they hear these cases, they're looking at the record that's already been developed. So we don't have any new evidence at the Fifth Circuit. They're just looking at the decision of the hearing officer, the decision of the U.S. District Judge, looking at all the records and everything and the testimony that was presented. And then the Fifth Circuit looks at it. And now tell us what did the Fifth Circuit have to say about everything?
The Fifth Circuit did exactly what the district court did. It affirmed the district court. It said, you are correct. The school did not provide FAPE. They didn't plan for the elopement. They didn't get something in place for the student that had been in a private school this whole time, and then we transitioned over to the middle school. It also said, the attorney's fees, you're going to get them because you did prevail on significant issue.
Okay. As
But
we
it
know,
also-
the attorney's fees, sorry for interrupting you there, but attorney's fees are always important in these cases, right? It's because that can be a significant amount. So there might not be monetary damages, although, private school placements, compensatory services can add up, but attorney's fees can also add up. So it's always important in these cases when a court will allow for attorney's fees.
Definitely the case. And in this instance, they said yes. And it did change the relationship. That's the whole thing. Why do you get attorney's fees? If you get relief that changes the relationship of the parties, then you're going to get attorney's fees.
Sure.
And the court found, yes, by finding that this was inappropriate, you had to develop a new IEP, you had to get a safety plan in place, you're going to have to reevaluate the student, all those things change that relationship. But the Fifth Circuit also upheld the district court's denial of compensatory services. It said it's an equitable remedy. Compensatory services are to right or wrong. And it said it doesn't mean you always get them if the relief that has been granted would address the harm that you received. And so in this instance, the Fifth Circuit said district court was correct in not awarding compensatory services, which to me, the school came out pretty lucky because at least from the facts that were in a decision, and remember, you don't know all the facts, you only get what you read, but in that, clearly there was a good argument that this child would need compensatory services in order to address the previous lack of progress.
Yeah, that's an interesting reflection on that case, because as you presented the facts, it seems like compensatory services would have been something that, or could have been something that would be granted in that case. Okay, so what lessons do we learn from this case? Can you offer us any of your sage advice and wisdom?
Of course. You know, I'm always going to offer advice. That's definitely something I have no end of.
Yeah. So what can school districts learn from it is really what we're looking at.
I'll give you some of my thoughts on this. The first one is, if we as a school place a student in a private school, then we're still responsible in making sure the kid gets FAPE if they're at a private school, because it's our placement. It's an IEP committee's placement. And so you need to continuously monitor what's going on with the students in that program. For example, you should be getting, beginning of the year, middle of the year, and end of the year, basically assessments of where the student is functioning, so you can see, are we making gains or not, and make adjustments to that IEP in order to ensure that they make gains, not just behaviorally, but also make gains academically, because those are certainly what we want to work on. And it's the child, like this might also be communication, social skills. We're working on all those together. But the other part is
out of sight, out of mind.
Yeah, it's still your kid.
Yeah, and it would be easy to do that. You get caught up in the day-to-day operation, and you've got so many cases to deal with. So that's good advice, because it is true. You place them there, and you're still responsible. As a public school, still responsible for that child's education. Okay.
In essence, it's just an extension of your types of programs. The other thing with that is, obviously he went over there for behavior. And so when you're looking at behavior, and they had significant enough behaviors that got them over to a private placement, then we have to look at doing new evals on a student, including a functional behavioral assessment, so we can ensure that behavior intervention plan is appropriate. Meaning, we gotta make sure the functions are still the same, and we're dealing with, because if the student hasn't been with us for a while, we don't know exactly what's going on with that student. And odds are the functions may still stay the same, but they may not. And so we have to look at it from that perspective. You certainly should be working on a functional behavioral assessment before the student leaves the private placement, including, I think, having a reeval in every area would be helpful, so you can see where they function academically. And those issues are there. A lot of times, obviously, as a student has autism, so communication is going to be an issue. Where are they in this area? And then based on that, you always get the prioritized behaviors. Aggression is always going to be one you're going to work on. Even if a student has a lot of behaviors, aggression and elopement are issues of danger. So you're going to be working at those for sure. And so if a student has elopement, you need to address those main behaviors in your BIP when you work on. So your transition should begin early. It shouldn't begin like 2 weeks before the student's coming back. It needs to be going, I would say, when you place a kid in a private school, you're working on transition from the beginning that they get placed there, so that you can look at, when can I get them into a less restrictive environment? Because clearly the public school is going to be a less restrictive environment in a private school that's only for students with autism. You don't have neurotypically developing peers for communication, for social skills. And so I think the quicker you can get a student back into a school environment, the better for everyone. Yeah. And so that'd be one of the lessons.
That's good. What you talk about in that transitioning, that's a good point, that the information may not have changed much, but at least right? At least you've looked into that, and now you know what you're dealing with. Because I think where schools get into trouble is when they just forget it and let it go. And like you said, if you wait till the last second, it's too late then. It's too late. Okay, any other lessons from this case?
The one that I would bring up, not because the school lost on this, but because they had a very high potential of losing, was on the compensatory services. As I indicated before, if we see a student is not making progress, then we've got to make sure that we come back to a meeting and make adjustments to the program. There are some instances where students, due to factors we're unable to control, they may have things going on. for example, they're not putting them on medication. That can definitely impact whether they make the kind of gains they make. But we want to make sure we do that. The other part is when a parent requests a different type of placement, I would go visit the placements if they're not within your public school and see what they have. And do we have the ability to provide that? And I would say with public schools, we can provide anything that a private school can. I really do believe that. But the other issue is if it's within your school, then in this instance, they were asking for the high school versus middle school. Then go see what the high school has versus this middle school. Are they the same? What are the differences? What's better for the student? The decision of where the student should be placed is the IEP committees. And so don't reference the special ed director or the superintendent says this is where they're going to be. It's going to say the committee determined this is what's appropriate. But go through those options in the committee meeting so that the parent knows that you have considered them, but you still felt that your placement was the appropriate place.
Yeah, it's good. Just, over the years, that is true. A lot of times when the private placements, they can't, the public schools can match that and usually do more with a lot of the related services type things. And sometimes the private placements aren't providing that, or they're not even really for educational purposes. So that's good advice. Okay.
The other thing is private school can't and normally doesn't have neurotypically developing peers. They don't have people for the kids that are just gen ed students.
Right.
And so we're always going to have that, which is an important thing for all students to have appropriate models for behavior, for social skills, and for communication.
Yeah, least restrictive environment.
There you go.
Absolutely. Okay.
LRE.
Any other lessons from this case, or is that
At
pretty
this
much
time,
it?
I think that's pretty much
That's
it
very
for
good.
go.
Well, it's very good. It's a very interesting case, an important case. We will provide a little summary for this. If you go to nellylaw.net, we will have a written summary of this, with everything that Cynthia just went through on this. And
A link to the case.
yeah, absolutely. Absolutely.
Well, have a great remainder of your day.
Yes. And thank you for being with us, and we'll see you next time.